Greetings and welcome back to the CBMW podcast. I'm your host, Jonathan Swan, the executive editor of Icon, a journal for biblical anthropology. I'm joined by the executive director of CBMW, Colin Smothers, and we have a special guest today. His name is Jon Whitehead. Jonathan is a Southern Baptist, an attorney based in Lee's Summit near Kansas City, Missouri. Jonathan specializes in cases representing religious nonprofit organizations. He served as co-counsel in multiple Supreme Court cases involving religious freedom. And in 2013, he obtained an injunction against the Obamacare abortifacient mandate. He's a graduate of Harvard Law School and most recently served as a trustee for the Ethics and Religious Liberty Commission of the Southern Baptist Convention. Like myself, Jonathan is a Missouri Baptist. We're also both proud alumni of Southwest Baptist University. The one thing we have against Jonathan, though, is that he's on the wrong side of the state. We need to get him over here to the east. And on this week's episode, we're going to talk about Jon's recent article in Icon titled "The Law in Parental Rights," as well as the recent Supreme Court decision, United States versus Skrmetti, in which the court decided 6-3 to uphold the state of Tennessee's law that prohibits transgender treatments for minors. So, Jonathan, welcome to the show.
Good to be here. Very good to be here. Thank you.
Colin, welcome to the show.
It's good to be here. You know, you said Jon's on the wrong side of the state. He's just closer to Wichita, you know, Jon. So
I know.
Maybe it's you who needs to move.
Potentially. I'd love to get you both back over here. I say back over here. Get you both over here. Hey, before we begin, we have a special announcement. CBMW and Icon just released our spring 2025 issue. This issue focuses on parenting, parental rights, the natural family. We have essays from Katie Faust, J. Allen Branch, and you can find the journal on our website, cbmw.org/journal. It is available in both PDF and online format. So go take up and read Jonathan's article, read all the others that are in there. So, Jon, in your recent Icon essay, you examined two Supreme Court cases, one being the Skrmetti case we just mentioned, and you tried to explain these cases in light of sort of the two spheres of authority, parents and the state. Can you explain the cases and the issues that are in play in these and the principles that you use to reason how we ought to adjudicate them, though they are similar?
Yeah, so both of these cases involve claims about the right of parents to decide fundamental issues for their kids. On the one hand, we have parents in Tennessee that say they should have the fundamental right to decide for their kids medical care, but by that they mean transgender surgery or what has become called affirming care, although in many cases it is not really that affirming. It is damaging and dangerous care. But the right to decide for their children the child's gender or the child's medical treatment, even if the state thinks that treatment is harmful. And on the other side, we have parents in Maryland that have said they've just the government provided education through the public schools in Maryland is infringing on their fundamental right to direct and guide the upbringing of their children. And in that case, they'd asked to be able to opt out of it's almost a crime to call it education, to be opt out of indoctrination sessions
right.
in the school on the issue of gender and sexuality, including now quite famously in the transcripts a book that's supposed to teach the alphabet, but teaches concepts like leather and queen through the lens of a drag parade. So it familiarizes children as young as kindergarten and first grade with those concepts. And religious parents in Maryland said, we have the fundamental right to say no to that kind of education. Mm-hmm. And the state of Maryland, the school district there, says no, they won't allow opt-outs, and they have a compelling interest in educating students or young students on these issues. So really two very difficult, thorny questions. And as I said in the article, it really makes a hash of evangelical rules of thumb, right? We might like to think, well, parents should always win. But we don't really believe that parents should always win. There really are times when parents harm children, as much as we hate to think that. That's not the majority of parents, but certainly there can be such a breakdown in family relationships that the parents do harm their children. And we do want the state and the church to step in within their appropriate spheres of jurisdiction and provide support. But on the flip side, we do want to control the right of, or control the education of our parents. We do want the state not to be seen as the primary educator, to not have the primary responsibility over children, but as a supplement, as an encourager of the family sphere, not as a detractor or opponent of the family sphere. So they come along at a very interesting time, and it will be interesting to see how they both play out. Neither of these cases are done, actually. We did just get an opinion in Skrmetti, and if you read that, you said, well, this doesn't talk much about parents' rights. There's a little bit in the dissent about the importance of parents' rights, but the way the cases came up, Skrmetti had both individual plaintiffs represented by the ACLU, and then the United States government intervened under the Biden administration. The Biden administration could only raise the question of equal protection. Do these laws discriminate on the basis of sex in a way that the Constitution allows or not? And the court affirmatively says that these laws do not discriminate on the basis of sex, that they don't violate equal protection. But the parental rights question the ACLU raised, and the court has never ruled on that question. It's just kind of floating out here on the docket. And so I see the guess of experts that I respect in the field is that the court will eventually, once it decides Mahmoud, the second case we talked about, it will instruct the lower court to reconsider its holding in light of whatever's going to happen. So there's the parental rights discussion is still coming. There's going to be an opinion, and what is said in Mahmoud will end up affecting the outcome in Skrmetti as well, ultimately. So stay tuned. It's all in the future still. It's not in the past.
Hey, John, on this question, I was actually able to recently have the privilege of writing a research brief for a large law firm that does advisory and defense even at the Supreme Court on the question of parental rights. So we actually put a précis of this in ICON, this issue, kind of some, principles that should be in play for evangelicals thinking through the question of parental rights in the state. And I think your article really, in a great job, outlines the two sort of sides of the horse you can fall off on. One is to give maximal deference to the state in these questions, and the other is to give maximal, overriding deference to the parents, even with disregard to the health and the well-being of the child. And one of the frames, I want to just test this out for on you with your legal mind. One of the frames that I was using was, child's rights being sort of a balance in the question regarding parental rights. And, I know that rights themselves are sort of a modern concept, but I think sometimes useful. I think useful encapsulating more of a classical understanding of what is best for the human being as a creature created in the image of God. And so that image-bearing status belongs, yes, to the parent, to the father, to the mother, but also to the child. And one of the things that I raised in that brief and in the principles was, a child, and a human being has the right by God, a God-given right, to be able to reach maturity with your reproductive capacities intact for the purpose of human flourishing, for the purpose of family itself. So a parent never would have a right over their child to do bodily harm, even spiritual, social, moral harm to their children, such that their own ability to form families is hindered. So in other words, there's a parental or even a familial frame to the question of what is the limits of parental rights, and it has to do with the generations coming on. And of course, parents don't have that kind of sovereignty over the human individual who himself or herself is an image bearer. Is that kind of how the legal reasoning goes, or what are some of the questions at play when, for instance, the Supreme Court is going to try to adjudicate between the state and the parent?
Yeah. So, it's an interesting question. Is that the way the legal reasoning goes? So I think you're right, for example, to say that one of the paramount concerns in deciding these kinds of cases is what's in the best interests of the child and the public, right? There's a public component to our individual decisions. And it's good and right for the government to encourage uh, outcomes that are the best for not just the individual but for society as a whole, right? And so we would like people to want what's good for themselves and for society. And I think that should be a non-controversial position on government, but it's unfortunately controversial in places if you try to pit the individual against the government or against the public interest and say the individual's whims or even beliefs should always win. And as much as Baptists obviously are great protectors of individual liberty, we want within the right sphere to protect each individual's right to do towards God or to as towards society what they think is best. But in terms of laying down government and making decisions for people, we do have this kind of public component. And so you say, is that the way the law works? Well, in terms of most decisions about children, no, we have kind of a best interest of the child standard that perhaps only indirectly gets there. Indirectly takes up that public component, in that would it be best for the child to have this outcome in the future where they are able to form a family? So we might think of it that way. But there isn't really a balancing of the public and private in the same way, right? So it's a very indirect way to bring it up. So that, in terms of where are most of these decisions made? By family courts. For example, let's say there's a dispute between parents about the course of action over a child that says they have a confused gender. That's going to be a family court decision in most cases, and the court is going to say what's in the best interest of the child. And we do have this divide in America right now, where we have kind of the professional class that says, well, it's in the best interest of the child to give the child whatever they say they want.
Right.
And the divide between that and the view that it's in the best interest of the child to prepare the child to live in the society in which they have. And that's not a bad thing. Both that is the world they have, and certain aspects of that are good. I mean, almost as interesting as the opinion that came down was the article in the New York Times the next day talking about how the transgender movement hijacked both science and politics in ways that ultimately really hurt the chance of Democrats at the ballot box last year, and almost irrationally, right? As an outside observer, you thought, how are they irrationally holding on to these arguments and this view in ways that they know will hurt them? And sure enough, they did. They had a moral or compulsion, really, to hold on to these views. And so the article goes through both the ways in which the ACLU brought probably an ill-advised case that was ill-timed, but felt they had to, the ways in which the government, because of President Biden's situation, advanced age, perhaps mental incapacity, was not tuned into the issues, viewed this as a way to get transgender kids access to therapists, not fully understanding that it was about surgeries, and frankly not fully understanding that it was the left trying to block kids from getting therapy under so-called conversion therapy bans. And then finally, the level of gerrymandering that goes on in these professional organizations that are supposed to be neutral scientific arbiters of truth, but they are consumed with politics and imaging and legal issues and insurance contracts. And so the discussion in the New York Times, kind of allowing it to be all on the table, this was not a scientific fact. This was a crusade by the ideological left that overtook science, overtook politics, and ultimately has harmed children. So both of those items are good to get out on the table. There is a discussion that the ideological transgender left has gone way too far in saying that it's good to harm children and get that out of the way so that they're consistent. And that's the opposite of life affirming, as we've seen with folks that end up regretting that decision.
John, when we had first asked you to write the article, we discussed that we were thinking it would be maybe a parental rights question. And actually, just a little backstory here. I drove to Louisville in December for our Icon editorial meeting, and Colin was frankly triggered after listening to the oral arguments in the Skrmetti case and said, we need to do an issue on this, and said, okay. We all got together and came up with some of the topics, and your essay was one of the first we had thought of. But we mentioned that that's not the case that they took, the Supreme Court took, nor was it the decision that was made. How did they make the argument that this isn't a violation of the 14th Amendment? What did they say? And are there what are the downstream effects of this decision, you think?
Well, so, I mean, the court as a court of limited review gets to decide the questions it answers. And so, in essence, they said, well, first questions first, does this violate the federal Constitution as to equal protection? And so that is the question they deemed to come first. Now, as I've said, there is still a direct discussion of parental rights that's about that has been raised. And so there will be an opinion about that at some point that addresses that more directly, because there were, in the oral argument, there certainly were some references to parental rights. Mm-hmm. And the posture of the case is that this was mostly a case brought by the parents of transgender youth, represented by the ACLU, and then the Biden administration decides to jump in. So that was just the question the court agreed was the first question to take up in a logical order. They could have probably taken it the other way around, but they decided for whatever reason, equal protection is going to be the first question we address. And that probably is because equal protection is one of the most confusing doctrines of the court. There are big words in lots of places, but the court repeatedly says, no, you've applied that wrong when anyone tries to apply that wrong. And so we really do kind of wait for them to tell us what that precedent means. So it was an important decision. That question, are we going, given we have transgender rights have been on the advance up through Bostock. And so the question is, are they going to go the next step, given what Justice Gorsuch wrote in Bostock? Are we going to have the next step and enshrine this group as a protected class or quasi-protected class in the government or in the constitutional law? It will be really interesting to see what effect this decision has. There have been several conservative commentators that said, we're grateful for the win, but this is very narrow, cramped argumentation. It's not a full-throated defense of man and woman and complementarity. It is a very narrow defense of, well, if you reversed roles, you would still need a medical diagnosis, and so therefore it doesn't violate the Equal Protection Clause. And that will be hard to replicate in other areas. We've got other issues coming down the pike. What's it mean to be a man or woman in sports? What does it mean to be a man or woman in housing or restroom facilities or all these other issues? And it will be hard to replicate this pattern in those cases.
Yeah, let me ask one more question. I think I know your answer. As these cases, we get maybe more broad and the cases get bigger, is the court going to be able to continue to give these narrow decisions? Like, right, this one there's two discriminations. It's an age issue and it's a medical use issue. boys and girls sports will have to be argued differently. Is it possible? Are there court precedents, legal principles that will allow the court to escape fundamental moral and metaphysical claims? Can they do it without those things?
Ultimately, no. If you want to preserve those things, that of course is the short answer, is that you can't dodge the question forever. Chief Justice Roberts has a judicial philosophy of slow and deliberate pacing and change. And so I'm sure in his mind, it's not time to jettison Bostock. But as others have said, a lot of the language in these opinions come from Anthony Kennedy. That is the framework we're still dealing with, where Justice Kennedy, as the swing vote over 20 or 30 years, was able to craft, in essence, an attempt to not take sides in ultimate questions, but also to say that the law can't govern unless it finds some other basis besides disapproval. And ultimately, that's not possible. I think that might be the goal of certain kinds of liberalism, but it's a false neutrality.
John, speaking of liberalism, you mentioned Kennedy, and wasn't it Kennedy and Casey who defined the heart of liberalism, or the heart of freedom, to be the right to define the very existence of life, or something like that? I mean, that's sort of what we're dealing with here. To your point, it's sort of Kennedy's court until we have a return to nature, a return to the givenness, the real, the reality of the created order, which, I want to say, I think Alito was actually trying to push this court this way. So he did join in his concurrence, but then he wrote his own, and he actually thinks that there needs to be, and possibly there is in this case, discrimination towards transgenderism, because transgenderism as a status is not immutable. That was one of my favorite exchanges in the discussion, the debate at the court back in November that John mentioned. It was that
the one where you were triggered.
Yeah, he was grilling the DOJ lawyer, and he was saying, is transgender status immutable? And they of course say, well, yes, it is. And then he says, well, is transgender status applied to those who are gender fluid? Which, think about that for a second. Gender fluid means you don't have a gender, or it maybe changes, literally changes.
Change. Sure.
Yeah. And the lawyer said, well, of course, gender fluidity is an immutable characteristic, a literal contradiction before the court. And Alito essentially is like, I rest my case. So that appears in a concurrence in this opinion. However, that Roberts wrote the majority, it's this narrow question. It doesn't rise to this, it's only an age issue, it's only a medical issue. But you do have Alito, at the very least, seeming to want to get back to a reality-based judiciary. And I appreciated that.
Yeah, I mean, obviously, there's some question about how fast can you react to Bostock. Assuming Justice Gorsuch was wrong or thinks he was wrong, there was lots of conservative pushback against Bostock. But they're not quite willing to give it up yet. But yeah, as you look at Roberts' opinion, it is hard to find words of disapproval. It's just, well, this is a choice. The child has a choice, and the government has a choice or an interest. And so how do we balance those interests? And like you said, that is very much still the world of Anthony Kennedy. And so the question is, can you avoid that forever? And I think the answer is no. There are important social governable realities that are not scientific, right? That some would say is a matter of metaphysics, that we would say is an expression of natural law or order, but others would say, well, that's just religion because we can't test that, scientifically test that in a laboratory, that's how it's supposed to be. But even when we can find X and Y chromosomes and XX chromosomes, say scientifically this is the way it's supposed to be, then you have the mind warp that says, no, but I don't want it to be that way. And so how can you govern my choice to not want it to be
or
that
worse?
way?
Not only do I want to, but you have the right to deny the very facts of nature, the very facts of science, because of some notion of rights or liberty. You know, back to our earlier discussion, this is where conversations about rights are so narrowly tailored to the frame of the individual that we've completely jettisoned, you know, family rights, parental rights, states' rights, you know, rights of governments to order society toward, you know, human flourishing as for the good of the whole society considered. And so that's where I think you're right. This court is still sort of hung up on this individual rights thing. I see some maybe push in a different direction. I'm hopeful. Bostock didn't give me any any confidence, especially when Gorsuch was doing what he was doing. However, this does seem like a little glimmer of hope. I mean, the Skrmetti case, I think we said this, but it's called United States versus Skrmetti. Skrmetti after the Tennessee Attorney General. It's such an indictment that this was the United States versus Skrmetti. It was Biden's DOJ who was suing Tennessee, the state, because Tennessee was trying to protect its youth. And Biden's DOJ says you can't do that because of some farcical notion of individual rights. And I'm grateful that they got a slap down, but I want to see this go a lot further.
Yeah, no, I think that's right. The New York Times article had the interesting details. Obviously now, after Team Biden has lost the election, there's a lot of recrimination, but blaming Rachel Levine, who was the highest ranking transgender official in the White House, for Levine went out and publicly recommended that they remove age limits on puberty blockers and hormonal treatment. And that was a step the White House didn't expect to be taken. And so there was lots of criticism that the official had gone out way in front of the White House, and then there were conflicting opinions in the White House about what to do. All that's nice to know later that they kind of regret they let things get out of hand. But it is an indictment of the way the government has worked on this issue and the way the scientific establishment has worked. And frankly, the way we believe argument should work, right? I mean, we all have this very hopeful idea about, well, the truth will win out. And it does, I think. But as Warren Buffett said, the market can remain irrational a lot longer than you can remain liquid. That can be a long period, right? And so we don't right now have adequate tools, or the system is not quite set up to encourage truth in these specific areas. It can be captured by ideology. It can be captured by medical or economic interests, and when children are being harmed, it's certainly time to sit down and have a long talk about, well, then what should the system be that can adequately protect kids? If this, as much as we appreciate the American system that's developed, if it can lead to this result here on transgender issues, if it can lead to the restriction of liberties we saw under COVID, if it can lead to that, then what are the major reforms we could do that would bring about trust in our experts in our government? And if we can't have that conversation, then these institutions are not going to succeed.
Absolutely. Jon, thank you so much for joining us today.
Good to be here.
Well, you can find more about CBMW and our ministry at cbmw.org.